everybody. Welcome back to my channel. Thank you for viewing, and I want to say thank you to Amy for coming back again. Amy Goodblatt is a mediator and divorce attorney in the Orlando area, and she's been on this channel before. And tonight we are going to be speaking a lot about mediation. I think there's a lot of misconceptions about the difference between mediation and litigation, or I just wanted to kind of have a whole video that just really does a deep dive into mediation. So Amy, thank you for being here.
And Lee, thank you for inviting me. I'm really excited to talk about mediation. It's a passion of mine. It's at this point almost about 80% of my practice, and I'm very, very excited to talk about it.
Great. So full disclosure, Amy was actually the mediator in my divorce. She is a divorce attorney, but she was the mediator that my attorneys chose. My attorney and my ex's attorney chose to mediate our divorce. So both of our attorneys were there at the mediation, but Amy was the one who basically talked to me and talked to my ex. And the way she set it up, I think maybe primarily just because the attorneys that we had didn't get along that well. But needless to say, we were in separate rooms, and she went from one room to the next. And that worked really well in our mediation. I know different mediators do different things. Nowadays, they have Zoom as well. But Amy, can you actually explain to us, like, what is when people say, oh, we completed in mediation, or we have to go litigate? What are they saying when they're saying that?
Okay, so mediation is a process, right? And the concept behind mediation is self-determination. It's a form of dispute resolution. It's an alternative to going to court and having a judge take control of your case. And it gives the participants in whether it's a divorce or a modification or paternity case or any family law matter or any legal matter for that matter. Mediation is an opportunity for the parties who are most affected by the outcome to retain control and become the decision makers. So, what mediation is, it's almost a role reversal. When you go to court, the judge is in charge of everything, the judge is the decision maker. If you have lawyers, your lawyers are there telling the judge what you want, why you're right, why the other person's wrong. And you, as the participants, the people who are involved in the litigation, are just witnesses in your own case. You're just like a small wheel in a cog.
Mm.
Mediation says that doesn't make any sense. What we should be focusing on are the people who are most affected by the outcome of this case, and let them be the decision makers and let them be the judges and make decisions with the assistance of their attorneys, if they have an attorney, or with the assistance of the mediator. And so the outcome of mediation is generally an agreement which is enforceable by a court. 99% of all mediation agreements get signed by the judge. Judges do review them to make sure that no laws were violated or no one was coerced or under any kind of duress. But generally, almost all the time, they're signed by the judge. And most people are, in fact, are more satisfied with an agreement they actively participated in, because in mediation, you are going to have some skin in the game. You're going to be the one who said, I evaluated my risks, my options. I listened to the people around me, my lawyer, the mediator, talk about what I could get in court, what might happen, and then I made the decision to sign, as
Right.
opposed to someone else taking that control from me.
Yeah, absolutely. I definitely went into mediation for my divorce with the goal that we would complete in mediation. And I think so many people, they hear divorce and they automatically assume court. And I think that it's a misconception because most divorces actually do get settled in mediation, right?
95% of all family law cases never make it to the courtroom for a final hearing. Maybe some small hearings along the way, but lawyers gear up for court. But whether you settle it on your own, whether you settle it in mediation, or whether it's very rare to actually go to court. People settle on the courthouse steps. They get there the morning of, and someone says, "Hey, can I talk to you for a minute?" And they settle. But the vast majority, mediations in the state of Florida, family law mediations, 75% of the time statistically are successful in gaining a resolution on some or all of the issues. And that's why the court system really likes mediation,
Yes.
because it judges are overworked, right? They only have a limited amount of time. And mediation is so self-directed, right? You not only do you have a voice in the outcome, you can pick a time that works for you. If you find a
Yeah.
mediator who will work on a Saturday or Sunday and that's what works for you, you can do that. You can mediate at 9 o'clock at night. You can tailor make a mediation to what works for you. You don't have to be in a sterile courtroom. As Lee mentioned earlier, you can be, as we said, on Zoom, you can be in your own home, you could be in your bedroom, you could be on your back porch. I've done several mediations where people have been outside by themselves, right out in their backyard, but overlooking something peaceful like a
Mhm.
lake or just some grass. It just makes them feel better, right? So you can situate yourself, you can eat, you can go to the restroom when you want. It's a much more relaxed way to to problem solve and resolve issues.
Yeah. So, and another thing, like my lawyer and my ex's lawyer agreed to hire you as our mediator. And, they said to us, this is the mediator we recommend. This is who we want to work with for this case. We think she's a good fit based on you or us or whatever, the dynamics that they chose. uh, what is the difference between people who mediate with a court assigned mediator versus an independent mediator, like the situation we had?
Mhm. Okay, so private mediation. So there's some, if you mediate through the courthouse, there's actually courthouse mediation programs in all of the state of Florida. But there are income limitations because you pay nominal fees for those mediations, and it varies county to county. But generally, for example, in Orange County, Florida, if a family together makes more than $100,000 a year, you're now ineligible for a courthouse mediation. So one
Gotcha.
party could make 102,000, the other person could be a stay-at-home parent, and you can't use the courthouse mediation.
Mhm.
Um, I also mediate in the courthouse. I don't just mediate privately, and mediators are good. It's not a difference in terms of the quality you get.
Mm,
Um, Courthouse mediations now are done by Zoom and in person, so it doesn't really matter, which you choose.
okay.
But the fee component of it is a little bit different, and you do them in 3-hour blocks in the courthouse. So if you do
Okay.
in Orange County, Florida, for example, you get assigned a 3-hour block. You can take two of them, whereas the private mediator, you can go 10 hours. I just finished one now that was 7 hours long straight through lunch and everything.
Wow.
Um, but you can be a little more flexible with those things. But in terms of who the people are, some of the same people do, most people do private as well as courthouse mediations, unless you're in a county like Volusia County has a mediator, a full-time mediator on staff. So you don't get a choice of a lot of different people. You get this one
Mhm.
individual. Um, and it depends, every case, sometimes you feel like someone will understand you better. So if you can look at the credentials of mediators through the courthouse, they are all posted in Orange County, all the circuits. So you might say, I want someone who speaks Spanish, or I want someone who's over 50 because maybe I'm in my 70s and I'm some 30-year-old isn't going to understand me really well. You
Right.
might want a male or a female. You might want someone from a certain part of the country. And credentials are listed on the courthouse mediation. The same in private mediators. You want someone you think your clients will listen to, or you as a participant want someone who's going to hear you. It could be a
Mhm.
religious thing. You may be an observant of a particular faith, and you might want a mediator who's familiar with that, whether they observe that faith or not.
Mhm.
You may feel uncomfortable with someone of a particular faith. Maybe religion is an issue in your case, and you don't want a mediator who has particular religious affiliation because you want your mediator to be neutral. And
Right.
mediators are required to be neutral. We all carry with us implicit biases. You can't help it. Things you may not recognize. Ageism is a bias. Some people think, old people um, don't have the capacity or the ability to make decisions like a young person. Some people think young people are can't make
Right.
decisions. They make impetuous decisions. So you want someone who's going to suit the people and the personalities of the people because you want to be heard. When you're in a mediation, and as an attorney, in addition to being a mediator, I want someone I think my client will listen to. If my client is anxious, you may want a therapist mediator. If you have a
Mhm.
lot of children's issues and parenting issues, you may not want a lawyer mediator. You may want someone who is a mediator who really is a therapist and has an understanding of maybe you have a gender issue with your children.
Mm.
gender, non-conforming issue, all kinds of things. You may have a lot of
Right.
financial issues. What there are accountants and CPAs who are mediators in divorce cases.
Huh.
So maybe your issues all financial,
Right.
right? And you don't have children. And maybe it's not about anything, but we have 5 businesses. One was given to me by my parents, 3 we started during the marriage.
Mm.
One we got after the divorce was filed. And so you need someone to kind of guide you through the finances and who has some knowledge about taxes and so forth. So
Right.
finding someone who at least will understand the terms. They can't tell you what to do, but it's nice to have a mediator who's familiar with what you're talking about.
Yeah, I definitely like recognize that a mediator who can speak to you and you trust the information they're sharing, even though they're neutral. Like our situation, my ex chose a very bad lawyer, hence why we were in separate rooms, someone who he didn't do good research. I don't know why he chose such a crazy, horrible person, but he stopped listening to his lawyer probably like an hour into the mediation. He told me after the fact because his lawyer was just like, no, we're going to court. No, we're going to court. And he didn't want to go to court. And I think he realized, all right, this guy isn't going to help me. And so I think he put enough trust in you negotiating without his lawyer helping, but that was because you were a solid mediator who was also a divorce attorney who probably wasn't leading him, but at least sharing like, well, a court, it probably might look like this.
It is helpful to find someone you think your client will listen to it. And some of it is a fit. You may have a miss. You may think your client will listen to that mediator and they won't. Some
Hmm.
people need a lot of hand holding and they need someone who'll be very soft and gentle with them. Some people need a mediator who's going to tell them like it is and say, I know you feel this way, but go spend an hour at the courthouse or a half a day and listen to your judge and find out how much sympathy they're going to have. So I
Mm,
think at some level, also you want someone, if you have a lawyer, that your lawyer's going to listen to, right?
yes.
If your lawyer thinks that mediation is a joke, they're just there to check a box on the way to
Mm,
court, you're not getting the sort of results that you want. But
no.
it's a fit. And again, some mediators are so good, it doesn't matter. They'll be a fit for anybody. But
Yeah.
first impressions count, particularly
Mhm.
on Zoom, more so than in person. On
Right.
Zoom, you walk in, you're in this room and you see someone like, oh, is that what that person looks like? And you form impressions right off the bat.
Yeah.
And I think it's very, very important that you're able to connect and feel that you can express yourself in confidence to this person and that they will try to carry forward your goals and they will try to help you achieve as many of your goals as possible. And even if the news is bad news, even if it's, I know you came in expecting to get all of these things, maybe they're not all achievable, but they will help you reconcile that. The mediator will help you understand and say, I understand that there's a statute. I'll use an example. In some cultures, it's offensive to people to be ordered to pay child support, that they feel like you're
Mm,
telling them they don't support their children. And I've had
mm,
this happen on more than one occasion and in this particular ethnicity. And so what I sometimes will do is say, here's the statute. It says the court shall order. You don't have discretion. So it's not
mm.
that anyone's saying you won't do it. It's in every case court
Yes.
requires it. So I think that that's very, very important that you have a mediator who's willing to maybe go the distance, go a little bit above and beyond, and make sure that you don't make any mistakes and that you don't end up in court for the wrong reasons.
Yeah, absolutely. And to follow up on that, so a couple who believes that they potentially should be able to complete in mediation and they don't want to go the traditional route of hiring 2 attorneys, paying these large retainers, let's say, and then they now have to do mediation with a mediator.
Right.
They believe that they can probably come to most of the agreements between themselves and a mediator. And then they just want potentially each maybe having like a consulting attorney to review the MSA. Is there like a name for that process?
No, it really isn't a name for it, but many people do that. I recommend. no matter what you do, that you have an attorney review whatever it is you do, because particularly people with children, there are long-term consequences to making agreements. And the fact that you didn't have a lawyer is never a good defense in court. So the
Yes.
courts do not allow, if you sign something and you didn't have a lawyer, that's not a basis to set it aside. So whether
Right.
you have an attorney available to you the day of mediation, or you put a clause in the agreement that says everyone has 21 days, and if no one withdraws in writing from this agreement, this is the agreement. You can go to a lawyer, not go to a lawyer. I just think there's so many long-term consequences to signing an agreement. It's important to find someone who would just give it a once over. If you
Yes.
you can also hire a lawyer just for mediation. So, there are
Hmm.
people say, "I don't need the big retainer, but I want someone to sit with me through the mediation," who, maybe you brief them about the case. They may charge you a fee to be in the room or on the phone
Yeah.
or on Zoom with you. You have to let them know what it's about, but it's not they're not drafting the pleadings, they're not you doing all the court hearings, they're just helping you make sure you didn't miss something. I'll use a very simple example, things something missed frequently. Life insurance, right? People
Hmm.
all talk about child support and they forget that if you die, even if you're the party receiving the child support, not the person paying the child support, there's value to the person who's perhaps a stay-at-home mom, right? And
Hmm.
if you pass away and the days the children are with you, the dad who the children will end up living with, right? Or after the divorce is final and they live maybe 50% with mom, 50% with dad. Mom dies, now they're 100% with dad. Dad now has to find a caregiver to help him care for the children because he's at work and he can't take them to soccer practice and all the things that mom may have done. And that
Gotcha.
there's a cost for that, so
Yes.
yes, there's Social Security, disability, but it's so simple. Most people have some form of life insurance through their employment or privately, but people forget to put it in their agreements. And then they find out that the spouse had named their new spouse right before they died, or they named other children as beneficiaries. And typically there's no cost to it, but something easily forgotten. And boy, it would really come in handy if an ex-spouse died to have 100,000, $50,000 to help educate your children, or to hire a nanny or some cleaning help, because you're
Sure.
struggling to keep up with the kids when you have
Hmm.
them 100% of the time. So that's a simple example that I see when people come to me a lot and they've settled on their own and they've forgotten to put in that requirement that they maintain life
Yes.
insurance. Just a simple example, something a lawyer can do for you that could be very valuable in the long run.
Right. So, yeah, a lot of my clients now, as a coach, are looking to hire a mediator. And then the way we discuss it is that they have an attorney who's kind of like a consultant who they, one of my clients, they've done multiple rounds of mediation, first for some small things, and then they speak with their consulting attorney briefly in between. Um, and is that generally what you would call them, a consulting attorney
Sure,
or?
sure.
Yeah.
And not everyone does it. If you go in, you could meet with an attorney and have a checklist, right? When you talk to someone, don't keep it all up here, right? If you meet with a lawyer and maybe you don't have a regular ongoing relationship, have them generate a checklist for you, things to look at mediation. Don't forget this, don't forget that, don't forget the next thing. Bring a checklist with you to mediation. The other
Mm-hmm.
thing, particularly if you're going without lawyers, every when I mediate, I always send people a financial affidavit to do unless they've already done one for the court.
Mm-hmm.
The court's going to require it to divorce you, except if you have very limited resources and you have no children and so forth. But 90% of the time, you're going to have a financial affidavit in court anyway, and you have to exchange them before you can have a valid binding agreement. So I
Hmm.
do send them out to people before mediation and ask them, if I'm doing mediation without attorneys, to make sure they've completed them and shared them.
Okay.
Why is that? It's a bind. If your spouse had a account in the Bahamas and they didn't tell you about it, 5 years from now, if you had that affidavit signed that didn't show the account in the Bahamas and you find out about it, you can reopen your divorce case and get your share of
Um,
the account. But if
okay.
you don't look at anything, and they said, "Oh, I told you about that. You knew about that account." You can rely on that affidavit under oath. This was your
Mm.
income. These were your expenses. These were our debts. So people do agreements that say, for example, I'm taking our all of the debts in my name. Okay. And then you find out that there were some joint debts that were omitted, right? Whose debts are they? So things that are omitted, if you have a financial affidavit, you can say, I relied on this. This is all I thought there were. So very
Right.
important to do that. And
Yeah.
and then you could just use that as a checklist. Okay, we talked about this, we talked about that,
Right.
move right
I
through
would
it.
assume any mediator who's running a mediation would require the financial affidavit. Is that not always the case?
Well, there are different styles. So some mediators feel so the theory behind mediation is we're not allowed to give you legal advice. So
Mhm.
I view it as if why would I bother getting a mediation agreement and then have it get decided by a judge because you didn't have the necessary paperwork. So I
Yeah.
send out affidavits and say, please complete them. Often people come in with them not completed, they're half done, but at least
Wow.
people do
Okay.
them enough so that they can disclose their assets.
Yeah.
I don't feel like I've done you a service as a mediator to allow you to leave my office with a signed agreement that I know a judge is going to set aside. So
Yeah.
part of mediation is you're allowed to agree to what you want to agree to, okay?
Uh-huh.
But if I know that you've reached an agreement that says the mom has the kids all the time and she gets no child support, a judge is not going to approve that unless you have a a reason. You have to have something in your mediation agreement. There was no child support because during the marriage, the mother inherited $14 million, right?
Okay.
And she uses that to take care, or the children have trust. So I've had this happen where children have been beneficiaries of trust from the grandparents. And the
Uh,
parties are minimal income earners, but they've agreed that those trust funds will be used to raise the children. Or
okay. Yeah.
so, or the disability payments coming in. A parent, a spouse, father might be disabled, and his disability check goes to the mom, right?
Hmm.
And we just say that in the agreement that mom receives $733 in disability. That's to be used for father's disability. That's to be used as, it's just an explanation of why you're doing it that way.
Right. Right. Yeah. I think that like Florida, I think it's wonderful that they require mediation before you can ever, aside from like maybe temporary assistance or whatever, you're not going to show up in a courtroom before you've actually sat down with a mediator and gone through. Is that pretty much standard for most states at this point?
Not as much as Florida. Florida's sort of a leader in mediation. I don't know every
Mm,
single state in the country, but many states do have a similar process, but I would still say Florida's at the forefront. And there's two reasons for that. One you'd like to think of as they want you to resolve your disputes. That's sort of the goal. But there's also
yeah.
a practical thing. Judges in Florida are overwhelmed with cases, right? The judge in Orange County average caseload's 4,000 cases per judge. 4,000, right? A significant number of them need to settle, or you will never get hearing time with a judge. I mean, you never get in the door. And what judges find, and I have many colleagues and friends who are judges, is that they have all these hearings set and trials, and the day of or the day before they settle, right? So the concept behind mediating before you go to the court is you've tried to resolve. A lot of lawyers get busy. Maybe I've been trying to reach out to the other side to settle and they never return my phone call. But as we're walking in the door of the courthouse, it settles. Well, meanwhile, that judge has an hour that they could have devoted to someone else's case had we
Mm,
gone to mediation and tried to work it out. So
mm,
some of it is judicial economy and judicial efficiency to say,
smart.
let's give everyone an opportunity to sit down and try before you get here because any judge will tell you they have these schedules like pack, 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 and then you come in on Monday and the whole week folds. And the
Mhm.
problem is you can't fit another trial in right away, right? You can't fit in another here because the lawyers need to plan their time, the parties need to plan their time. So but also, isn't it better to come to your own agreement? I mean,
Yeah.
judges don't know your family, they don't know your
Mm-mm.
children. Private school. So here's another example, right? Private school, the court cannot order unless you agree to it. Or the children have been in private school all
Mm,
along. And it doesn't matter how rich you are, judges are not allowed to just order private school. So if you are someone who believes in private school and your children are kindergarten and first grade, maybe they've gone for a year or two to private school, but it's not enough of a track record, and your spouse says, no, there's no private school. Right?
right.
Whereas in mediation, you might make some concessions around that. You might say, we'll keep them in private school through fifth grade. We'll meet by the end of fourth grade and determine if we're going to change that, right? But a judge can't do that. Judges can't speculate. So in mediation, you can be creative and do things like, here's how we're going to share time with our kids until they're 10 years old.
Right.
And then we're going to change the schedule. So with very young children, you may do substantial time sharing, but you probably don't want your children to be a week with one parent, a week with the other
Yeah.
parent. It's very difficult for young children to be away from either one of you for long periods of time.
Hmm.
But by the time your kids are 10 or 12, they may need longer schedules because they keep forgetting their homework in one house. So
Right.
the
Sports
assignments,
equipment.
yeah, the assignments come out on Monday, the test is on Friday. So you really want to change that schedule. A judge in a courtroom is not allowed to say, here's the schedule till your kids turn 10. At 10, you're going to change it to this. In
Yeah.
mediation, you can. You can do
Mhm.
automatics and say, unless we agree otherwise, it will automatically change to this. Very young children, vacations. You may say when your kids are really little, you don't want them going away on a 2-week vacation with either parent 2 weeks next to each other. But by the time your kids are 12, you may be totally fine with either parent taking a 2-week vacation or
Right.
half the summer. So there's a lot of things you can bake in a
Mhm.
mediation that you can't do in a court.
Right. Yeah. I'm thinking back to our mediation. Our situation was so unique because my ex was staying in the Philippines for his job and he would come back here for his 20% custody here, but he wanted, 5% of the time to be there in the Philippines. And we agreed the first 2 summers, his company would pay for me to bring the kids over to the Philippines for 2 weeks. And he would have the kids for those 2 weeks there. And that's a really unusual situation and agreement that I was willing to work with him, but you're not going to have that happen in a courtroom.
Well, remember, there's no case law on that, right? So it's not like a judge is going to say, oh, this is the Adams case, and I'm just going to
Right.
follow the law. So you're leaving a lot of discretion to a
Mhm.
stranger. And judges have odd ideas sometimes about what will work for your family that may not be consistent with your own values. People are
Mhm.
often shocked. Now, we have a statute now that says there's a presumption of equal time sharing for children.
Right.
Didn't used to be as of July 1, 2023, equal time sharing. Well, that means when you walk into a courtroom, if you walk in and say, but my spouse has never been home, they travel all the time, they're going to walk in with a presumption you have to fight against that. In mediation, if you say, look, you travel 3 weeks a month, I'll give you the fourth week of the month, you don't have to
Mhm.
worry about overcoming presumptions. You can continue doing what you've always done. Now, a judge
Right.
can overcome a presumption, but you have a lot more freedom for how you do this. You could say, hey, if you ever get a job where that doesn't require travel, frequently
Mhm.
people's, job
Change.
circumstances change and you know
Yeah.
what you're getting. So the other thing is when mediation, when it's done, if you agree on something, you know what's going to happen. You may
Right.
have a very old-fashioned judge who doesn't believe that young children should be away from their mom for very long. That's not the law anymore. But
Yeah.
you may have someone who's come back as a retired judge to help out when they have overflow, who hasn't tried a family law case in 20 yeyears, and they're thinking about how it was 20 years ago, not how it is today. So
Yeah.
very important. COVID,
Interesting.
COVID was a big thing. Vaccinating your children, right? There's no case
Mm.
on vaccinating your children. That's a shared parenting decision.
Right.
So there was a lot we could do with that in mediation. I had many cases where we agreed that we would let the child's pediatrician make that decision.
Wow.
Who's your kid's pediatrician? And how long they've been going there? 6 years. You like the pediatrician? Yes, I like the pediatrician. Okay, well, if you two can't agree on immunization, would you trust your child's pediatrician, the one who treats them when they get sick, to make that decision? I probably settled 3 cases with that same
Wow.
idea. Let's let the
Interesting.
pediatrician, the person you trust with your child's health, advise whether it's appropriate for your child to get vaccinated. So
Hmm.
there's a lot of things a judge cannot order that. He cannot
Yeah.
order that judge just decides.
Right. So the outcome, the document that comes out of this mediation, that's the MSA, right?
Correct.
Okay.
Marital settlement
So,
agreement and parenting plan.
and parenting plan. And I think it depends, or does it depend on the mediator or the lawyers who decides who's going to write up that MSA once you've completed the mediation?
Okay, so generally, it's preferable for one of the parties, if there are attorneys, to write it, not the mediator, because mediators are bound by ethical rules as far as not injecting their own input into the agreement. Now, frequently, it's not feasible to do it that way. The lawyers haven't come with a draft, or they're parties without attorneys, and I don't want people left to their own devices. So many times, media will draft what I call bullet points. I'll do an agreement that will have bullet points in it, so it's not biased either way and everyone reviews it. The Florida Supreme Court also has a marital settlement agreement, one with children, one without children. And I
Mhm.
can use that document and say, okay, this has not been drafted by me. We're just going to fill in the blanks, take out the things that don't apply, include anything extra. But it is important that your mediated agreement, if it's an agreement or a parenting plan or both, get filed with the court. There's no magic, right? They have to get into a court file,
Yes,
and they're not orders until a judge signs off on them.
yes.
So if
And I
you're,
think that's
go ahead.
really important for people to understand. I think they leave mediation sometimes thinking like, okay, we've agreed upon everything, but until it's signed by both of you and the judge, it is not a legal binding document.
So if you sign something on Thursday that says my time sharing every other week starts on Sunday, and the other person doesn't show up and you call the police, they're going to say, there's no order here. There's nothing
Mhm.
I can do for you. So you can either have a final order, which is your final judgment, or you can even just have something simple prepared called an order approving. You file the agreement with an order approving the agreement until you get to final judgment. People who
Mm,
don't have attorneys in some counties, um, everything is screened by the courthouse because they want to make sure that when you get in front of the judge for that final hearing, that there's no issues or problems. And that can take 6 weeks to get your documents screened. But you can send over a little order approving that agreement, and the judge will sign off on that. It may not be your final judgment, but at least it gets your agreement in place. Maybe it's really important. So as a mediator, I might say, if you want to go out of the country with your children, right, for
yeah,
summer vacation, and you mentioned the Philippines, right? That's, and you want to go and you're afraid your spouse may change their mind, you can say, order approving paragraph 3 of our agreement, wife may travel to the Philippines. I would draft that for you and say, now you have to mail this to the judge or you have to email this to the judge. Here's how you do that. But just filing an agreement doesn't end your case. You have to have an order to conclude your case.
right. Yeah, if I look back on our process, I think what you did, you sent bullet points to my lawyer's office. They sent a draft to me and to his attorney, but the time it took for my lawyer to draft it and then to send it to his attorney to look at it, and there were some issues or mistakes, just typos, address incorrect, just stupid things. But then to get it back from them to my lawyer, we ended up, and this probably is unusual, but we were amicable enough at the time, is we asked for it in a Word document and then we redlined it ourselves back
Wow.
and
Okay.
forth, because we went back and forth because our mediation was only like 4.5 hours
Right.
long and we only did one. But we then tried to eliminate our lawyers for a lot of it, and then took that final document that we'd agreed to and had at least my lawyer look it over. And
So,
then,
yeah, it is preferable to come to mediation with a pre-drafted agreement, even if it has a lot of blanks in it. Okay. Because
yeah,
once people leave that room, I mean, the bullet points are good, but if anything's up to interpretation and the redrafting takes long, in your particular, and I don't remember this part of your case, but in general, I have done cases where I've drafted after the people have left. I've like someone had to leave to pick up their kids, whatever's gone on.
yeah,
We've agreed on everything. And I've said, I will finish the agreement. Let's come back Tuesday for 1 hour, right? I will draft
uh,
it tonight. You're going to pay me for an extra hour of my time, but I will email it to you tonight. Look at it, review it, redline it. Let's get together for an hour or 2 hours, short, and let's
yes,
get it signed then and there. I'm a big believer signing while you have momentum because the
yes,
wait is awful. It's awful.
yeah, it
Make sure
is.
make sure you ask for enough time. So the other thing is everything takes longer than you think.
Yeah,
And if most mediators, I only charge for the time used. I don't have a
mm,
minimum.
yeah,
So if someone asks for a whole day and we mediate for 3 hours, I just charge you for the 3 hours. I have lots of other work on my desk to do.
right. Yeah, no, our situation was the way it was because his lawyer had to leave our mediation at a certain time. So it was mostly done. It was done enough that we could do that redlining. But I will say I have a client who they finalized everything in mediation over a Zoom mediation. Her ex was very difficult. She was shocked that they actually got through mediation. Then he refused to sign, a few weeks later once it was drafted. And, then it was months of dragging out
Right.
again. Like, so I do think that momentum come into signing when you're both kind of there in agreement, at least, even if it's a draft that needs to be.
Another
Yeah,
trick, right? Another trick of the trade is if I send it out to you afterwards and schedule another time to come back. If you guys look at it and it's okay and you sign it on your own, you call and cancel, right? As long as you don't do it the morning of, there's generally no fee. You should
yeah.
charge like a 1 day's notice because I could put something else in your slot. But so you have
Mm,
that out. Hey, if we like it or it's pretty close, we can revise it on our own. But knowing there's a deadline, a return to come back, a return date
yes.
makes everyone do the work. The problem is, and this is a lawyer thing too, mostly, I've got a lot on my desk, right? And so I'm gonna, if I have a deadline tomorrow and a hearing
Sure.
tomorrow, the day after, your mediation agreement, oh, there's no deadline, it's just my client's
Yeah.
getting unhappy, right?
Right.
So you want to be the squeaky wheel who gets the grease.
Yes.
And also your lawyer's recollection of what happened at the mediation. It's gonna be
It's
very
not there.
fresh, right? That
Yes.
day. After that, everybody's recollection diminishes of what happened.
A hundred
And
percent.
mediators don't often save their notes. So because mediation is confidential, we're not required to save the notes. And there are many mediators who immediately when you leave shred their notes because it's confidential. They don't want to be asked what happened in the mediation if there's a problem because we're
Oh,
not allowed to talk about what happened in mediation. So if you
interesting.
want your mediator to save the notes because we're working on drafting, ask your mediator to save his or her notes.
Oh,
I've had
that.
people ask me to send them my notes, and then I will never do. Number one, I have the world's worst handwriting. Second of all, I make doodles and I do other things in my notes, and there's a lot of confidential information because I may be talking to you. We may not
Sure.
even do that, and then I go talk to you. I might say wife said, husband said, and
Right.
and and I don't want you to get the wrong piece of paper.
Yeah.
So, but I will save my notes if everyone agrees. Mediator, please save your notes. I will definitely do that.
Right. Yeah, that's interesting. I didn't know that. I took detailed notes during my mediation, so I was like, I feel like I trust my notes over
But
everybody
most
else.
people do not. Most people do not take
Uh,
notes.
so that's the next topic I wanted to come to. I went into mediation feeling very prepared. Like I'd researched divorce, I understood kind of like based on Florida law, like what I felt based on our length of marriage and situation was a fair settlement. Like I kind of went in with my own, I'd done a lot of like just soul searching, like what do I need to get myself on my feet? How long will I need that? How should it taper? And so like I went in with like a very clear idea of what I thought was a fair request for my side of the negotiation. And I think that helped me, one, feel confident, but two, like feel like, no, I'm negotiating and this is what I think is fair. And I'm going to work towards that. I had like a very clear end goal for myself. And I think because my ex's lawyer had misled him to this idea of like, oh, you're not gonna have to pay alimony or anything. Like he had no preparation, but he wanted to finish a mediation that day. And so he was kind of like not well prepared, which benefited me. But what I think is that a lot of people potentially go into mediation with the assumption that they're going to let their lawyers or whoever they've hired come up with what is an agreement that is good for them.
You
And
should
I
not
think
do that.
they should know what they want before they ever walk in the door.
Absolutely. You should have your goals in mind. Hopefully, you have a preparation appointment with your attorney, not the morning of, right? Like a week before. So, in case you think of something after, don't make it so far in advance you can't remember. About
Right.
7 days before, what to expect,
Mm-hmm.
um, your goals, and then if you can give your lawyer or yourself, you don't have a lawyer, your goals, and then what are you're flexible on, what
Yeah.
things that you're willing, so that you come in and you don't forget something, and that you're
Yes.
very clear. Because lawyers have styles if you have an attorney. Some lawyers come to mediation and they run the whole show, and their clients, they just ask them questions. Other
Yeah.
lawyers look at mediation as like, I'm on vacation or I'm going to work on other clients' work. Let the mediator ask all the questions
Yeah.
of the client. And so you want to know what your lawyer's style is going to be. Or you can say, if you have an attorney, am I going to be doing the talking? Are you going to be doing the talking?
Hmm.
Explain to me what this process looks like.
Right.
Mediators are required to do an opening speech explaining the rules of mediation. I take a lot of time in that speech because I never know how prepared that individual is for
Yeah.
mediation. And I explain that about self-determination and confidentiality, and that the benefits of mediation, and that you can decide an hour in, this is not for me. I don't want to do that. No one ever knows. No recording of mediations because they're confidential, but really going through in great detail so that if people have concerns or questions, they can voice them because I never know what kind of preparation they've had. But
Right.
as a consumer, and you are a consumer when you go to an attorney or to a
Hmm.
mediation, you have a right to know. Many people who come to me who don't have lawyers ask me a lot of questions about what to expect. you know,
Hmm.
why do I need 4 hours? And I'll say, well, you have children, there's no way I'll ever get a mediation done with child support in less
Hmm.
time than that. It's really
Yeah.
very rare. So, um, but people, you have a right to know what's
Hmm.
going to happen and what it's going to look like. That you may be, if you're in separate rooms, you have to tell the media, I want to be in separate rooms. So most people agree to do an opening statement together where everyone's in the same room, Zoom room or in person,
Hmm.
and then generally they separate after that. If there are things that can be decided together, I try to keep people together because it's fast.
Yeah. For
It's more
sure.
efficient. So, for example, if you're working on time sharing, holiday schedules, it's really very, very inefficient to talk about what time you're exchanging on Thanksgiving break in 2 different rooms, right?
Yeah.
So even if maybe you can't agree on what the week to week time sharing is like, can we talk about the holidays together? Which ones are important in
Hmm.
your family? Winter break, are you going to divide the break in half, or is one parent going to have the whole break? Is one,
Hmm.
are you religious? Do you celebrate Christmas Eve in your family, Christmas Eve, or is it Christmas morning? Get
Right.
some ideas that work for people, and some of those are more efficiently done together. Now, if one party, only one, says, I can't be in the same room with the other party, we're separate rooms. I'm
Right.
required to do that. But you can
Right.
start separate and come back. Maybe there's
Yeah.
something you thought about later. Maybe as the day goes on and your tension eases, you might say, "Oh, this would be so much faster if we could do this together." How you're
Right.
going to transfer assets, how you're going to pick up the furniture, right? What day it is, do you need
Yeah.
3 weeks to come get the sofa, or can you come in 2 weeks? What Saturday works for you? I find that many times people come to mediation so nervous, they don't wanna be in the same room, and 3 hours in, once we've got the big issues done, they
Right.
can sit down because the goal in mediation is to teach you how to communicate with each other, particularly for families who have children who are going to be in each other's lives forever, right?
Yes.
Your kids are going to get married, they're going to have graduations, all those things. And you want to be able to negotiate those family life cycle events, even when they're over 18, in a way that
Hmm.
everyone's comfortable, especially your children. So
Right.
mediation is a way to teach you to communicate a little bit, which is how you
Absolutely.
handle disagreements.
Hmm.
And you find maybe over time even the most unhappy relationships can find some areas in which they can agree. So, Labor Day
Definitely.
weekend, my family always gets together. I really like every Labor Day weekend. And then the other person might say, well, can I have every Memorial Day weekend? Sure, that's fine. That works.
Right. Yeah, like our example, we did all the time sharing stuff all in the same room because we had no issues with that. It was when it came
M-
to the financial
Money.
splitting of the assets where things were gonna definitely be uncomfortable. And I think it was better for us to be in separate rooms for that. Um, and I like my lawyer wasn't going to do any mediation prep. I asked, "Can I come in?" And honestly, we it was like 10 minutes and it wasn't much mediation prep, but it gave me the confidence like it's going to be fine. But as a coach now, what I do with a lot of my clients is help them think through, one, what are your goals in mediation? what are your non-negotiables? What are things that you're willing to negotiate on that you can use as leverage? And just the mental prep to go in confident and be willing to take a stand for yourself if you need to, and work with your partner to keep that amicable relationship. And I think that uh, if you do the prep up front, the day of is so much more productive and
It's
empowering.
manageable. So if you're
Mhm.
doing a great job in preparing people, and I think if you prepare yourself for, you know, and be flexible. You may come in thinking, "Oh, I really want it to be this way, and this is my bottom line," but maybe something happens during the mediation. You find out your spouse just got diagnosed with cancer. This has happened to me. It came with the medical records. They didn't tell anybody till they got there. Well, that changed the dynamic a lot. Or
Mhm.
you could find out that your spouse lost their job last week. And so while you were planning on this giant alimony, they might say, listen, for the time being, I can only do X. Or they suddenly have to start traveling, which they didn't before. Lots of things happen immediately before. And for
Yeah,
whatever reason, people think, oh, I have the mediation coming up. I'll tell them then. So you can go in with a game plan, but you have
yeah,
to be open to the situation. But you should come
sure.
in with your goals. If you have to write them down, what would make
Mhm.
this a successful mediation for me? Not a win, but what would I be satisfied with? I use that term a
Right.
lot.
Yeah.
Happy is not a good word to use for but what would
No.
satisfy me today? If
Right.
I could have time with my children, if I could make sure they go to private school, if I could, make sure they are on my health insurance, whatever that is that will satisfy you, and then list out some things that maybe you think your spouse might really want that you would be able to give them, right? That you can
Mhm.
throw in to make it sweeter for them.
Sure.
It may be
Absolutely.
something that means nothing to you, but means something to them. It could be a piece of furniture that is yours from your grandmother, but you don't really care about it, but that your spouse loves it, right? And if it makes a
Mhm.
difference, it can be the dog goes with the kids back and forth. I've done this a few times.
Yes.
So people get very attached to the dog, and dogs are property in Florida. They're not people. We don't have doggy custody agreements, but you can agree to it. So you can
Mhm.
say the dog will go with the children. I've done this many times. It's the children's dog, and the parents like
Mhm.
that, and the kids like that,
Yeah,
and it eases transitions for your children sometimes because they
for
feel like
sure.
they have their dog with them, right?
Yes, absolutely. Um, okay, this is all really good. Uh, I think I'm just looking to see if there's anything on here that I haven't asked you that I had um written down not to forget. What would you say, is there a typical number of hours that people should anticipate for like an average divorce with children?
Without children, probably 3 to 4 hours. With children, assume you're gonna be there 6 to 7 hours, really,
Yeah,
because unless you've worked some things out in advance, there's so many issues because children you have time sharing and child support to deal with. So there's a lot of extra issues. It's double.
yeah,
Unless you have a really complicated business case, factor that into your time. By the way, you can also mediate because that's a long time to be
yeah,
in with a room, and that's just you might decide right from the get-go that you want 2 separate sessions, maybe 2 weeks in a row, 2 Mondays in a row, half
yeah.
and half. One day we'll talk about property and the and money, and the next week we'll talk about children or vice versa.
Mm-hmm.
You may set that up in advance. I'm not a big fan, and I've done them. The marathon mediations that go till 10 o'clock at night from 10 in the morning. No one's at their best. They're antsy. Your blood sugar goes crazy. If you're in my office, I feed you. Um, but people get really snarky and
Yeah,
you just they're exhausted. And when you're on empty, you say things that you didn't mean to say, and you could have a whole day's worth of work thrown out the window, right? Because
yes,
someone gets upset and just says, enough, I'm done. And then you've
right.
done all this work
Ugh, that
and
would
out the
be
window.
horrible.
So but I think that's an expectation. Ask your lawyer or the mediator. I always say, what's everyone's time constraints today? Because you'd be
Mm-hmm.
amazed how many times I think we're there all day. And the lawyer will stand up and say, oh no, I have it on my calendar till 1 o'clock. Even though I've sent a letter saying you're booked from 9 to 5, And the other side's like, "What? We only have 3 hours or whatever, so or 4 hours?" So make sure you get the lay of the land. If you need someone to pick up your children, if we go past 2:30, try to have a game plan. It's really hard when you walk out on the mediation and say, "Oh, I gotta go get my kids," and nobody knew. As a
Yeah.
not all mediators may ask, I always ask, does any and by the way, I've had people leave, pick up their children, and come back, and we keep mediating. But
Huh.
it's but I can if you tell me that, hey, between 2:30 and 3 o'clock or 3:15, someone has to get the kids. I don't think I'm gonna have to do it. So I spend the time in the other room with the other party, or I'm
Right.
drafting during that period of time.
Yeah.
Or sometimes a lawyer will have to do a Zoom hearing in the middle of mediation. So I will try to work. I have a mediation next week where one of the attorneys has to drive to a physical hearing, but they really wanted to do a particular day. So we're taking a 2.5 hour break at lunch. We're going to go from 9 to 11, and then we're going to pick up again at 1:30 and go for the rest of the day. And everyone knows that 2.5 hours at lunch. If the other side wants to keep mediating, or everyone just says, no, no, we're going to go do other things, I'll take them off the clock and we'll come back.
Yeah. Yeah. That's great. So
But
it's,
avoid surprises. If you know you have to take a phone call at a particular time, try to make everyone aware of that.
yeah.
The best practice is if someone if says something before you get there, right?
Hmm.
If you know your client tells you, like some people schedule doctor's appointments in the middle of mediation. I had a mediation one time where the attorney was so mad his client didn't tell him, "Hey, I have a 10:30 doctor's appointment, but I'll be right back." And he said, "No, you won't. What doctor do you have that takes you right away and you don't wait 45
Yes.
minutes in the waiting room?" So the meeting, he walked out and paid me the lawyer. He said, we're not doing this today. I'm not waiting for my client to go to the doctor." But get ahead of it. If someone sends me a letter saying, "I just got scheduled for an emergency hearing. I'm so sorry it's going to interrupt things." At least you've let people think through
For
what needs to
sure. It's
happen.
just common courtesy, I feel like, but
Well, people also feel like you're dealing with them fairly. It's the last minute pulling the
yeah.
rug out and saying, thinking you have a whole day and you're relaxed, your delivery, and having one lawyer come to you like 5 minutes before, say, "Oh, I forgot I have a hearing today. Bye, gotta go."
Yeah.
Everybody's left with a bad taste in their mouth.
Yeah. That's unfortunate. Um, yeah, I think that just respect, like respect for everybody else's time.
The
It just,
process, respect,
yeah.
right? That
Yeah.
and if emergencies happen, accommodate them, right?
Sure.
I had someone
Of
come to my
course.
office a couple weeks ago. I walked in, shook his hand, and then he said, "Oh, I've been sick since 3 a.m." He didn't tell me before I shook his hand. The next day, he was diagnosed with COVID.
Ah,
I did not send him home, and I should have. His lawyer was furious at him. We kept him in a room with a mask on the whole time.
oh my
Luckily,
gosh.
none of us got sick. But if you're
Ah,
planning an in-person mediation and you're exposed to COVID,
yeah.
tell somebody. Maybe we could switch you to a Zoom to an election,
Yeah.
we
Yeah.
have virtual options. Really, it's okay.
Right. Yeah.
I mean, I
Wow.
understand that, right? If you
Of course.
or if
Yeah,
in the
I'd
middle
much rather that than you expose me to COVID.
right, and so, I mean, it's okay. Things happen in life, right? That's all right.
Mhm. Yeah, absolutely. All right, this has been like jam-packed with information. I really appreciate your time. And I what is the best way if people want to reach out to you with questions about possibly having you help them with the case?
So, I don't know if putting it in the chat would anyone will see that, will
I can
they?
put it in the description for sure.
Okay, my name is Amy Goodblatt. My email is the best way to reach me is Amy, AMY, at AGOODBLATT.com. That's agoodblatt.com. Calling me by phone is not really a good way to get quick bits of information because I'm often involved in long mediations and interrupting and so forth. But if you send a quick email like that, it's very easy. You can also find me in the Florida Bar website. Glad to help out. If you have a question about selecting a mediator, what to expect, always glad. I love mediation. So let me close by saying I firmly believe that throughout your relationship or your marriage, when things were going well, the judge probably never came to your house to make decisions and to help you resolve arguments. Why should ending your marriage be any different, right?
Mhm.
You
True.
should, I mean, dispute resolution. Most of us have never had a judge ever come over and make a decision. keep control of your life, your money, and your children, right?
Yeah.
Make those decisions the smart way, the mature way. You'd be so much happier in the end. So that's what I like about mediation.
Yeah, that's perfect closing. Thank
Uh,
you.
All right. Well, it was good, and I'm glad to talk to anybody. And Lee, it's always a pleasure to talk with you.
You too. Thanks, Amy.
Good night.
Bye.